All right, Jail, are you able to see me now?
Yes, we can, sir.
All right. This is Mr. Niegos. Are you able to see and hear me?
Yes, Judge.
This is case number 253691 FY, the people of the state of Michigan versus Bobby Lee DuBois. We were scheduled today for a preliminary examination. However, the court received some information regarding some security issues. One is it was relayed to the corrections officer that Mr. DuBois threatened to punch the corrections officer. There was also a message that was intercepted by the corrections office through the communications system that was sent yesterday at approximately noon or 11:47 a.m. in which, from Mr. DuBois' account, it says, listen, I don't care no more. Says don't watch what happens. I don't even come to court tomorrow because I'm going to flip out on this mother effer, and that is not what's said, but I'll clean it up. I'm going to show them a side they've never seen. If I could get within an inch of a guard or with that prosecutor, I'm going to effing choke the life out of her. Due to the security concerns, the court requested that corrections take certain precautions in which to bring Mr. DuBois to the courthouse for his preliminary examination. However, the corrections officers could not do that because it's reported that Mr. DuBois may have broken an ankle or a foot due to mule kicking a door. So the court finds for good cause, due to security purposes, we are not having the preliminary examination today. That will be adjourned to a later date. Also, it's now determined because a threat has been made against the prosecutor, whether or not a special prosecutor will need to be appointed in this case moving forward. So that is going to potentially delay this case. We will reschedule it for again next week to see where we're at.
So we've rescheduled this 5 times already. That's why I'm in the situation
Mr.
I'm
DuBois,
in. No, I've been patient with you, Your Honor. I have. We are 55 days into this.
For the record, I have muted Mr. DuBois because he is interrupting the court proceedings. Counsel and I had that meeting in chambers before, and it was decided that this is how we were going to handle it. As I said, Ms. Carey is going to determine whether or not she needs a special prosecutor. Mr. Niegos, it's questionable as to whether or not he's the MFer that's referenced in the message as well. And it's my understanding he's going to make a determination as to whether or not he'll need to withdraw from the case also. Counsel, have I summarized what we've discussed and what's happened so far in this case? For the record, Mr. DuBois has walked out of the security or out of the communications room.
Yes, sir.
You have, Your Honor, in the interest of efficiency and to alleviate some of the concerns that Mr. DuBois started putting on the record, whether fair or otherwise, my plan was to have him briefly placed under oath and just inquire as to that simple fact. But I'm not sure that would be productive to do so today. I leave it to the court's discretion, but in terms of the court's question as to was that an accurate summary of what we discussed in chambers? It was.
All right. And for the record, Mr. DuBois is back in the Polycom room. So for those reasons, the court does find good cause to adjourn today, and we will be back on a different date and see procedurally where we're at. We are adjourned. Thank you.
Thank you, Judge.
This is case number 254159 SM, People of the State of Michigan versus Andrew May. Mr. May, did you read and sign this advice of rights form?
Yes, sir.
The contact information contained on the back of that, is that accurate? Did you have the opportunity to meet with somebody from the defender's office today? I need you to speak right up so we can make sure the recording's getting you.
Yes, sir.
I have a complaint that alleges that on or about September 7th, 2025 in the city of Cadillac in Wexford County, it is alleged that you committed the offense of assault or assault and battery on a Robert Lockard. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Consecutive sentencing may be imposed if it happened in a place of confinement. Do you understand those charges and the potential penalties?
Yes, sir.
That advice of rights form, did you actually read that form?
Yes, sir.
Did you understand those rights?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I request.
And what is your current source of income?
I make about 35 grand a year. I have CCI and Burger King. I have 2 jobs, sir.
All right, court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf, and we'll set the matter for a pretrial conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing in future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 23 a larceny less than $200 that was handled as a juvenile. Any comment from the defender's office?
Yes, Your Honor. I would ask the court to consider a personal recognizance bond. He obviously is here today. He has ties to the community with not 1, but 2 jobs. I don't believe he's a flight risk. I do believe that would be appropriate. If the court has any concern for public safety, I believe that could be overcome with a non-monetary bond condition, such as a no contact order with the alleged victim. I always advise people that's highly likely to occur. I don't believe that'd be a problem. Thank you.
Ms. Lawrence?
Thank you, Your Honor. I do understand there is a co-defendant in this case. This defendant had helped the co-defendant in assaulting the victim. The victim was pretty badly beaten up. He even got treated at the hospital for some of his injuries. Given that, the people will leave bond up to the discretion of the court. We would just ask for a no contact order.
Are you aware of any connection with the victim?
I believe it was an acquaintance of both co-defendants. There was some allegations of borrowing a car and that type of thing.
All right. Thank you. Mr. May, if I were to allow you to remain out of jail on your personal recognizance, which means to basically your promise to come back to court and follow bond conditions, is there anything that's going to stop you from doing that?
No, sir.
I will release you on your personal recognizance. You are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not have any contact with Robert Lockard or your co-defendant Douglas Willett. No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. Do you understand that?
Yes.
I'm also going to order that you not act in any threatening, intimidating, harassing behavior, and that you not purchase or possess any firearms or weapons. Do you have any questions for me about those bond conditions?
No, sir.
Because this charge does require that your fingerprints be taken, I have signed a fingerprint order. You'll need to get a copy of that order at the front window, make arrangements with the Wexford County Sheriff's Office to get those prints taken. You have to have an appointment to do that. You can't just stop in. If you don't do that, that's a violation of the court's order, and your bond and your criminal history won't be completed. Just a reminder that any violation of your bond conditions could result in you being arrested without a warrant, brought back to jail, and have your bond revoked. You understand that?
Yes.
You can go to the front window where you check in, get your next court date. You'll have some paperwork to fill out for the defender's office, and then you can get that fingerprint order. Okay, thank you. Douglas Willett. This is case number 254160 SM, the people of the state of Michigan versus Douglas Lee Willett. Mr. Willett, you completed this advice of rights form with your contact information on the back. Is that form accurate?
Yes, sir.
Did you have the opportunity to meet with somebody from the defender's office today?
I think so, yeah. Okay, sir. Yeah.
All right. I have a complaint that alleges that on or about September 7th, 2025, in the city of Cadillac, Wexford County, it is alleged that you committed the offense of aggravated assault upon a Robert Lockard. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000, and consecutive sentencing may apply if it happened in the place of confinement. Do you understand those charges and the potential penalties?
Yes, sir.
Did you read and sign this advice of rights form?
Yes, sir.
Did you understand those rights?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process. If you cannot afford one to be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney? And what is your current source of income?
Remodel hotels around here and 2 hours up north in Sheboygan.
The court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of the trial. You also have the right to have a bond set. The bond is based upon the probability of your future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 24, no license, operating without security, unlawful plate. In 24, operating without security. In 24, disturbing the peace and attempted resist and obstruct. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. I would ask the court to consider personal recognizance in this matter. As the court can see, he is here today. He does live in the local area. I don't believe he's a flight risk. I believe any concern the court has for public safety can be overcome with no contact order with the alleged victim in this file. I believe that would be sufficient. Thank you.
Ms. Lawrence?
Thank you, Your Honor. Same facts in this case. The victim was pretty badly injured. He was treated at the hospital. I believe the victim is an acquaintance of the defendant. Given that, the people just asked for a no contact order.
Mr. Willett, do you have any failed to appears in your past?
I think one in Benzie County. Where it was in Manistee, I'm not too sure,
How long ago was that?
like 4 or 5 months ago.
Has that been since resolved?
Yeah. It was a Zoom call.
All right, defendant does appear. I will release him on a personal recognizance bond. That's your promise to come back to court and follow bond conditions.
Yes, sir.
You are to appear as ordered, keep your contact information current, not leave the state without permission, and commit no new crimes. I'm also ordering that you not have any contact with Robert Lockhart or Andrew May. No contract means no contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. Do you understand that?
Yes, sir.
Additionally, you are not to purchase or possess any firearms or weapons and not act in any threatening, intimidating, and harassing behavior. This charge does require that your fingerprints to be taken, so I have signed a fingerprint order. You'll need to get a copy of that order at the front window where you checked in. Make arrangements with the Wexford County Sheriff's Office to get those prints taken. If you don't do that, that'll be a violation of the court's order and your criminal history won't be complete. You can go to the front window where you checked in, get a copy of that order, get your next court date, and you'll probably have some paperwork for the defender's office. All right? Thank you. Court next calls the people of the state of Michigan versus Stephen Ingelston. This is case number 254200SM. Mr. Ingelston, did you read and sign this advice of rights form? And the contact information on the back, is that accurate?
Yes.
Did you have the opportunity to meet with somebody from the defender's office today?
Yes, I have.
I have a complaint that alleges that on or about March 25th, 2025 in Herring Township of Wexford County, it is alleged in count number 1 that you committed the offense of larceny, $200 or more, but less than $1,000. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $2,000 or 3 times the value of the property taken. Do you understand those charges and potential penalties? You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Do you understand that? Today, I need you to speak right up so the recording equipment can hear you.
Sorry. Yes, sir.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Requested appointment.
And what do you do for income?
Yes, salvage, scrap, small engine repair. I do odd jobs.
All right.
It's self-employed for 25 years.
The court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show an 88 and a license, 88 a plate violation, 91 driving the license suspended, 91 driving the license suspended, 93 disorderly, 87 improper endorsement, and 88 another improper endorsement. Defender's office, any comment regarding bond?
Yes, Your Honor, obviously that criminal history is incredibly old, so I don't think it bears a lot of relevance. Mr. Engelson lives in Cadillac and he has for 7 years at least. He, like you mentioned, is self-employed. I don't see any reason that he'd be in the community and I'd ask for a review of bond.
Ms. Lawrence?
People would leave bond up to the discretion of the court.
Mr. Engelson, I'm going to allow you to remain out on a personal recognizance bond. That's your promise to come to court and follow bond conditions. I am going to order that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. Ms. Lawrence, is there a need for a no contact order in this case?
I don't believe so, Your Honor.
All right. Also, sir, because of the type of crime that this is, that you've been charged with, you are required to get your fingerprints taken. So I have signed a fingerprint order. You'll need to get a copy of that order at the front window where you checked in and make arrangements with the Wexford County Sheriff's Office to get those prints taken. If you don't do that, that'll be a violation of the court's order and your criminal history won't be complete. Do you have any questions about that? All right. I'll need you to go out to the front window where you checked in, get a copy of your next court date. You'll have some paperwork to fill out for the defender's office, and then you'll get a copy of that fingerprint order, all right? Okay. Do you have any questions?
I have another case at 145.
Probably subpoena for the Mindy McNamara home invasion.
Oh, okay. All right. Did you receive a subpoena for that?
Yes.
All right. You can have a seat out in the waiting room and they'll call you when they're ready for you. All right. Thank you.
On behalf of Mr. Failer, who's present here to my right.
We are here for a probable cause conference. Is there any resolution in this matter?
Yes, Your Honor, it's my understanding that the defendant is going to plead guilty to an added count of domestic violence, second offense, and the people will dismiss domestic violence, third offense, as well as the individual fourth notice. There is also been an agreement made in the circuit court that's been negotiated today, so I'm going to put that on the record, wherein the defendant would plead guilty to 2 technical violations, and the people will dismiss 1 non-technical violation upstairs.
Have the violations been agreed to as to what they are?
Yes, Your Honor, they have. There's only 1 non-technical violation and 2 technical violations filed in the circuit court file.
Do you happen to have that case number?
It is written on the plea sheet.
Okay.
I don't know it off the top.
Mr. Niegos, is that your understanding of the plea agreement?
It is, Your Honor. I've discussed that with my client as well as the advice rights associated there, and he's prepared to go forward with the guilty plea.
Mr. Failer, have you heard what the attorneys have said the resolution in this case is?
I have, sir.
And is that how you wish to resolve it?
Yes, sir.
Will you please raise your right hand as best you can? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
So it's my understanding that you'll be pleading guilty in this case to a domestic violence second. That is a misdemeanor punishable by up to 1 year and or a fine of $1,000. In exchange for that plea, the people will be dismissing the domestic violence third, which is a 5-year felony, and the habitual fourth, which makes that a life offense. Additionally, you also have an agreement that you would plead guilty to 2 technical violations in the circuit court, and the people would dismiss 1 non-technical, and that's in case number 2413871FH. Is that your understanding of the plea agreement?
Yes, sir.
No, counsel, I want to be clear on this. This is a global resolution, is that correct?
Yes, Your Honor.
And so, is there a date set for the circuit court matter yet?
I was planning on contacting them later this morning to advise of the resolution and ask for a date to be set ASAP.
Mr. Carnes, if we accepted the plea today, are we able to sentence today?
We are not, Your Honor. We've had some contact with the victim, but we haven't been able to reach.
So because if the plea in the circuit court doesn't go through, in theory, it would undo the plea in this court. So is there going to be a request to wait to see what happens in the circuit court before we sentence in this case?
No, there's not a request, Your Honor. Global might not be the best way to resolve it. In my opinion, this is a more serious matter. So I'm fine if this might separating. I think we arrived at this resolution together using both files, but I'm not, if he decides to have a hearing upstairs, I'm not going to ask if anything happens.
So they're not tied together. It's just as you sit here today, this is the agreement as to what's happening. But if it doesn't happen in circuit, this one doesn't fall apart.
Yes, Your Honor.
Mr. Niegos, is that your understanding?
That's excuse me, that's correct, Your Honor. Without putting the cart ahead of the horse and talking thus length like this, I don't anticipate any reasonable scenario under which the circuit court piece of it will fall apart.
All right. Mr. Failer, do you understand what we've talked about?
Yeah,
All right. Do you have any questions about that at all?
I do not, sir.
All right. So we already know back at this time, you were under some supervision of the court. That was parole. Am I correct on that? Probation. I'm sorry.
Yeah.
Probation. Were you on bond in any other file?
No, sir.
And I know at the arraignment, we went through your rights with you. I also have a signed advice of rights form here, talk about your rights to an attorney and your rights to a trial. Did you understand those rights?
I did, sir.
Most importantly, do you understand that you have a right to a jury trial in this case, and that by entering a guilty plea, you'll be giving up that right? You won't have a trial of any kind.
I do, sir.
Other than the agreements today, has anybody promised you anything?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plead today?
It is.
Counsel, are you aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor. Your Honor, thank you.
This is a guilty plea, correct?
Yes, Your Honor.
Mr. Failer, then to the allegation that on or about September 25th, 2025 in Clam Lake Township of Wexford County, how do you plead to domestic violence second?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on September 25th of this year, were you in Clam Lake Township?
I was.
And did you have some sort of altercation with Chelsea Aaron Smith?
I did.
What was your relationship with her?
Girlfriend, boyfriend.
All right. And how long had you been in that?
8 months.
So what transpired? What happened?
Yeah, I was early in the morning angry. I was angry and I threw a lighter. In her direction, yeah, absolutely.
Did that lighter hit her?
I do believe so.
You said you were angry?
Yeah.
So describe this lighter for me. Is it like a little Bic lighter?
Yeah.
Is it a Zippo or?
Correct. It's a big lighter.
Is that all that happened?
Yeah. Yeah. I mean, I thought she had my keys and she didn't. It was just me being.
All right. Do counsel believe the defendants provided the factual? Well, let me ask you. She didn't ask you to throw the lighter at her?
No, absolutely not.
All right. Do counsel believe the defendants provided a factual basis in which to accept the plea and the court rules have been complied with?
Yes, Your Honor.
Yes, Judge.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Failer, I find you, well, I do have to do one other thing. Is it true that you were also convicted of domestic violence on February 10th, 2022 in the 28th Circuit Court?
Correct.
Now do counsel believe that the defendants provided a factual basis to accept the plea and the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Failer, I find you guilty of domestic violence second. Pursuant to the plea agreement, the domestic violence third offense and the habitual fourth will be dismissed at the time of sentence. And Mr. Carnes, you did say we had to set this over for notification?
Yes, Your Honor.
All right, we will set this over for victim notification. And anything else for the record before we adjourn?
No, Your
Honor. Excuse me, Judge. I just, for sentencing purposes, Judge, my client is okay with me appearing via Zoom. I'm asking for the court's grace to allow me to appear via Zoom under these circumstances.
Mr. Carnes, any objection to that?
No, Your Honor.
And Mr. Failer, you're all right with that?
Yeah.
All right, the court will grant that request.